Good morning. All right. Okay, Miss Korndike, welcome. Um, this is your motion for a show cause hearing. Well, we're here in the matter of Ensing versus Schmidt, case number 22-03489 DC. What's going on, ma'am?
Yes, so I'm covering for Miss Smulders today. We filed this motion because there is an order that when the parties communicate on Our Family Wizard, it's supposed to be strictly about the child. And
Right.
um, there's been some stuff being said about my client specifically that I think falls outside of the purview of being about the child. Some derogatory things like that. There was another one after we filed of him calling her an evil manipulator.
Isn't this
That's
going,
something,
is, isn't through, isn't this stuff going through My Family Wizard or something?
yes.
Okay.
It needs to stop, Your Honor. Like it's outside of the scope of what they should be communicating about. Um, there's no reason for that. If they have issues, they have
Yeah,
issues, but it should be about the child strictly. And
right.
so that kind of behavior just needs to stop, Your Honor.
Sir, what's your response? I've read your response. What do you have to add to it for the record?
Honestly, I think that Marissa's frustrated that I'm finally making headway, getting some more time with my child. I finally got vacation time. I think she's just filing
Well,
petty litigation, and I don't think this is. Um,
Well, I don't know if there's enough to hold you in contempt here, but there is enough that I can look at you and say, knock it off. I mean, these communications don't have to be
okay,
at what they
All right, guys, listen up. The morning session kicks off with Judge addressing Ms. Corney in the high-stakes Schmidt case, 2203-489 DC. Tensions explode immediately as she presents the motion for a show cause hearing. She accuses Mr. Enning of sending derogatory messages about her client on the Family Wizard app, calling her an evil manipulator. Judge interrupts. Laying down the law, communications must be strictly about the child. Enough is enough. The courtroom fills with raw intensity as he warns, these communications don't have to be okay. Stop now.
are. You need to stop. You know, my problem, Ms. Korndike, is a lot of these communications are within parenting time requests and
Yes.
confrontations, but this is not for confrontation, Mr. Ensing. This is for communication.
I understand.
And you are becoming somewhat confrontational. And I realize it's in the context of you asking for parenting time, but there is no necessity for name calling or, just being blatantly obnoxious. But, just because being a jerk on these is not enough at this point for a for a contempt hearing, but it is enough for a warning to say, Mr. Ensing, when you're talking to her, you're talking to the mother of your child. Talk to her as such. Ma'am, vice versa. You're talking to the father of your child. And you're right, you should be upset about these. This is unnecessary, Mr. Ensing. And no, this motion was appropriate so that you can come into court and be told, grow up. Okay? So to that extent, I am enforcing the inherent rights portion of the judgment and the statute, which means neither one of you is supposed to disparage each other. That is inherently illegal. It's part of the statutes of the state of Michigan. So when you get that stupid, luckily, I don't think you crossed a line. I've seen a lot worse, Ms. Korndike, forgive me, in comparison. But it's appropriate to bring it in to say, admonish you and say, don't do this, because you're going to be coming back here, and the next time it may be enough for contempt, especially now that I've warned you.
Hold on, folks. The heat rises. Mr. Enning tries to justify his frustration over parenting time adjustments, but the judge slams down hard. He sternly emphasizes this isn't a playground argument, it's about communication, not confrontation. Name calling, out of line. Obnoxious behavior, unacceptable. He delivers a warning like a gavel to the chest, enforcing Michigan statutes against disparagement. The courtroom hangs on every word. Grow up, the judge says, sending shivers down their spines. Miss Corney nods, realizing this warning is serious next time. Contempt could be on the table.
Okay?
Understood.
Make your requests. If there's a no, either bring it back to court if necessary or work through it. If there's a yes, great. I mean, I didn't choose the parents here. Both of you did. You're going to be living with each other for a long time, hopefully. Okay? So, Ms. Korndike, as to show cause, I'm denying the contempt, but I am saying that this was appropriate for a warning shot. Okay?
Okay, yes,
Mr.
I'll
Ensing?
draft an order.
Okay, no problem. Good luck,
Thank you.
everybody. Thank you.
Thank you.
Okay, Mr. Quinn, you connected?
I can hear you loud and clear, Your Honor.
All right. Ms. Palazzolo, you connected? And Mr. Palazzolo, you connected? Good.
Yeah,
All right.
yes.
We are here in the matter of Palazzolo versus Palazzolo, case number 23-10327DM. Ms. Van Dyken, you are here on behalf of Mr. Reens, who filed this motion. What do you have to add to this motion, ma'am?
Your Honor, simply that I believe that he meets the threshold for Shade be right with regard to the parenting time. Mr. Palazzolo has changed his work completely in order to
Yeah.
be available. It benefits not only him, I admit that, but it also benefits the child, not having to be in daycare.
All right, fast forward. We hit Palazzolo versus Palazzolo. Case to 3103-7DM. Miss Van GJK speaks aggressively for Mr. Rees, advocating increased parenting time. She lays it out straight. The father changed jobs to be more available, benefiting the child and maintaining family stability. But Judge isn't impressed. He slams the brakes on endless litigation, exclaiming, 4 files in a year and a half. Ridiculous. His voice resonates with authority as he warns both parents to land their helicopters and stop dragging the child through unnecessary courtroom battles. The message is clear. Enough is enough.
Or have an au pair or a nanny, transportation, and it also benefits Miss Palazzolo. Let's not forget that she is, I agree, the primary physical custodian, but she would want her child to have a better relationship and a long-standing relationship with the father. So I think the court should set this matter for an evidentiary hearing so where it can hear the evidence with regard to the best interest factors and go from there. Thank you.
I guess let me set this up. So he changes his job, but he's doing the same type of work, correct?
Independent contracting, Your Honor, no longer.
But
under
he's,
the
yeah, the
guidelines.
hours are different. There is nothing in the judgment that ties it to his parenting time to the job other than the fact that he might lose a weekend because he has to work that weekend. So, yeah, I'm afraid that looking at this, no, what's going to do the child better is if these parties stop the continuous litigation. It's getting ridiculous. There shouldn't be 4 files on a case that's only a year and a half old. This is absurd. So no, this judgment was just entered 6 months ago. We're going to finally let the ink dry on something in this case and let it solidify. And you might be putting words in Miss Paula's
Up, courtroom drama intensifies. Judge reviews job changes, schedules, and custody logistics. He scrutinizes the arguments, insisting that the child's best interest trumps parental convenience. The parents are on edge, realizing the power of the gavel. The judge refuses to let litigation chaos continue. The ink must dry on prior orders. No more endless arguments, no more repeated motions. He reinforces that everyone must move forward responsibly. His words cut sharp. Stop this litigation. Move on with your lives. This is about the child, not your petty grievances.
all those mouth about, I'm sure she wants that relationship. She did. They negotiated this. He's got parenting time. That was already set. It was put in order. It was put in a judgment in October. So 6 months ago, we're done. No, we're going to let the ink dry on this and the litigation needs to stop. That will help the child. Yes, Mr. Quinn.
I don't have anything to add to the substance, seeing how the court, I think, has already ruled and denied the motion. Our only request would now be for attorney fees for having them bringing this motion.
Yeah, no, like I said, you guys got so many things in the works on this. No, not at this point. Again, you guys both need to land these helicopters and stop this litigation. Good luck.
Okay. I'll prepare the order, Your Honor.
Yeah, move on with your lives, please. Thank you.
Thank you.
Good morning, everyone. We are here in the matter of Massey versus Massey, case number 25-01127 DM. We are here to amend a temporary order. Ma'am, Ms. Pelto, I've read your request. Sir, what is your response to that request?
Your Honor, I would like this motion dismissed, just due to, there's a hearing on June 17th with, Judge DeLange.
Right.
I feel that I have, I've abided by the court orders, and I have moved within my 100-mile radius.
Uh-huh. And you made it almost impossible. Do you guys each have a vehicle now?
So I I'm trying to remember what date it was, but last week.
So she was ordered to do a lot of the transportation, if not all of the transportation, and you moved so far away that now she's got to pay all this gas and all this other stuff, and you guys only have.
Now we shift to Massey versus Massey, case to 5011 to 7 DM. Tempers flare again. Ms. Pelto requests an amendment to a temporary order due to logistical impossibilities caused by the other party's relocation. The judge listens intently, dissecting the move, vehicle limitations, and the added burden on parenting logistics. He lays it bare. Moving this far is pushing limits. Children spend over an hour in cars unnecessarily. Aggressive yet fair, the judge grants the motion temporarily, setting a strict tone. Parents must cooperate or face further court intervention. The courtroom feels the tension, every word echoing authority.
You have one vehicle that you can barely afford. That's why the judge set up the other thing in any event. So you choose to move away and have this kid spend over an hour in a car. You know, you've had this great parenting time, both of you did. The judge worked it out, and then you choose to move so far away that you make it impossible.
No, Your Honor. May I say something, please, Your Honor?
Sure.
So what had happened was I was going to finish my lease out in Grand Rapids.
Mm-hmm.
And I told friend of the court that when we had our recommendation,
Mm-hmm.
when Miss Massey got locked up for her domestic violence, there was a no contact order that was put in place.
Right.
And I did depend on Miss Massey for a lot of things. And with
Yes.
that no contact order, it really made it hard. So I moved closer to family that would help me, you know, with the kids while I was able to work. And also,
Where is your job?
I work for PTS Refrigeration.
Okay, and where is that located? Where is your job? Or you drive around to houses and stuff?
It's located in Howell, Michigan, but I'm given a company van where I am dispatched from my house.
Okay, and is that the job you had when the initial parenting time was issued?
No, my hours got cut, so I had to change jobs. It was during that time.
Okay.
April 14th, I did update my address and my
Right.
employment with friend of the
Okay.
court.
All right. What hearing is set for June 17th, Ms. Pelto? Is this going to be a divorce trial?
It's a settlement conference, Your Honor, at that point.
Okay. Yeah. Sir, I'm afraid you've made an impossible situation. I'm granting Ms. Pelto's motion, but it's a temporary order still. You guys still have the ability to maybe get this back to where it was. But for now, because of the impossibility and how far you moved, I know you moved within the 100 miles, but you still kind of pushed that one. So no, you know, at this point in time, I'm going to have no choice because of the impossibility of making this occur, that for temporarily until you get to that settlement conference and a divorce trial, I'm going to have to grant Ms. Pelto's motion out of necessity for now. Okay?
Yes,
Good
Your
luck,
Honor.
everybody. Have a good morning.
Thank you, Your Honor.
Finally, the judge drives the point home. Both parties are reminded the courtroom isn't a battleground for ego. It's a place to enforce order and protect children. He outlines the temporary rulings, but with sharp warnings: abide by logistics, communicate respectfully, and stop fueling endless disputes. Ms. Pelto receives relief, while the other party is cautioned to comply. The courtroom exhales, knowing the gavel is final. All right, guys, this is how justice looks when patience runs thin and rules must be enforced. The ultimate showdown between parental rights, legal procedures, and the unyielding authority of the court.